We are well past the point of a new trial and bordering on a full-out dismissal. Let's go over these most recent motions from the defense in the Richard Allen story. All that being said, everything's alleged. Welcome to the point. Let's get to it.
In 8 years since Abby Williams and Libby German were killed on a hike in Delphi during a day off from school, their bodies were found near the Monon High Bridge 8 years ago today on Valentine's Day. Their murder made national headlines, and until last November, their families waited years for justice.
We're still waiting for
That's when a jury
justice.
found Richard Allen guilty of their murder. He was sentenced to 130 years in state prison.
And new this afternoon, attorneys for Richard Allen claim prosecutors are trying to mislead the court.
And they're arguing that the Carroll County prosecutor should be held in contempt. That's all in a new filing today, the latest attempt to correct what the defense calls errors in the trial. There are several issues brought up in that new filing. Allen's defense argued that a man named Ron Logan confessed to Abby and Libby
And we're going to get to Ron Logan later on in the video. There's a ton going on with the Ron Logan situation as we know it.
forward testimony from a man who claimed that Logan confessed to him. The state says that man failed a polygraph test. The defense says that polygraph test was not part of the trial record and should not be allowed as a rebuttal in this case.
Prosecutors also shared video of a white van belonging to a man named Brad Weber driving near the crime scene. At trial, Weber testified that he drove his van by the scene at 2:30. That's around the same time Abby and Libby were, which prosecutors say scared Allen away. However, surveillance video shared by the defense after the trial shows him driving almost 15 minutes later than he testified. In today's filing, the defense says Mcleland either knew or should have known that the timeline was different.
And let's talk about the stupidity surrounding this scaring story that goes along with this van. I have always thought for the longest time it's 100% absurd to say an individual was scared or spooked. He rushed to pass away 2 individuals, changed their clothes, cleaned one, cut off branches, moved bodies, placed those branches on top of the bodies, and then tactically walked through the woods back to his car, not leaving any DNA in his car and not being seen by anybody. We knew that the prosecution was going to say the timestamp is off. They have no way to verify that it is off. But the defense is right. In the state's rebuttal to this motion to correct errors, they didn't put any affidavits with any of this. Or at least the vast majority of it, meaning this is all Nick Mcleland's own guess, his own words, and his own interpretation of the evidence as he sees it. But you need affidavits. You need expert testimony validating what you're saying, and that just wasn't provided, and it's a huge problem.
They also accuse him of either allowing false information at trial or of never correcting the record.
And there are more details in this filing.
Absolutely.
In a footnote of this new filing, the defense floats the idea that Mcleland should be held in contempt of court for filing photos of Libby's cell phone into the public record. You'll remember that Allen's defense team were reprimanded after someone connected to their office leaked crime scene photos before that trial. The filing also accuses Prosecutor Mcleland of misleading the court.
Now, Fox 59 is leaving key information out of this thing. Let's go to the motion, and I'll tell you exactly what I'm talking about. On page 9 of the state's response, Mr. Mcleland says Sergeant Cecil was able to observe photos of the phone when it was found. Herein attached the state's exhibits 9, 10, and 11. And this is what leads you to the contempt part of this particular discussion. Because the judge said at the request of Nick Mcleland, none of these photos should be leaked out. But here he is dropping 3 of them. And we all remember the stink they made over those photos being leaked by the defense. Now, will he be held in contempt? I highly doubt it. But this is the defense saying we see what's going on. And in a lot of ways, they're being kind of snarky about it, saying you did this and we did that. This is what happened to us. Let's see if they're going to let it happen to you. Now, if nothing comes of this, it just validates what a lot of us are saying, that this is not a fair trial and this wasn't a fair process. If the court does hold Mcleland in contempt, I'll be absolutely shocked. But here's the key piece of information that they didn't talk about in that news article. In addition to not saying whether Sergeant Cecil actually observed these photographs, this allegation by Mr. Mcleland is based on facts outside the record and unsupported by affidavit or verification in violation of Trial Rule 59H2. And this is the important part. Also on page 9 of State's response, Mr. Mcleland alleges that Sergeant Cecil's testimony that the log entry on LG's phone reflecting that the headphone behavior could have been caused by a malfunction due to dirt or water in the headphone jack was based on his knowledge and experience as a forensic phone examiner. Sergeant Cecil's trial testimony about the possible effect of dirt or water in the headphone jack was based entirely on a Google search. And we have talked ad nauseum about the stupidity behind the court allowing a Google search to be entered into evidence. I mean, in terms of a criminal proceeding, if all we have to do is look everything up on Google, what is the point of experts? In fact, what is the point of lawyers? This part of the testimony should have never been allowed at trial. That's all we're saying. There should be standards in the courtroom. There should be fairness in the courtroom. And the fact that there was no standards and no fairness with this particular trial bothers a whole lot of people. But there's more to this stupidity. Listen to this. Performed during a break in Mr. Allen's trial. The allegation that Sergeant Cecil's opinion then had anything to do with his knowledge or experience is based on facts outside the record and unsupported by affidavit or verification in violation of Trial Rule 59H2. On page 10 of the state's response in subparagraph 4L, Mr. Mcleland says, and I quote, "There is nothing in the logs, reports, or extractions that would indicate whether or not the phone had some kind of water damage because that kind of damage is not registered in the logs, reports, or extractions of the phone. Whether or not there was water damage can only be determined by physically examining the phone. Mr. Mcleland is not an expert and attempts here to testify as if he were one. Every single allegation of this subparagraph quoted above is based on facts outside the record and unsupported by affidavit or verification in violation of Trial Rule 59H2. And when you go read the state's motion to correct errors, they attached affidavits to everything. They did everything within their power to validate what they were saying, to say, here's the stuff that we gathered to prove what we're talking about right now. But there's no affidavit with anything Mcleland said. It's my understanding that Libby's phone would have registered the difference between a headphone jack and water damage. And here's the reason I believe Nick Mcleland was willing to risk it all and violate that court order and possibly be held in contempt. The big takeaway surrounding the phone isn't that it had water damage or didn't have water damage. We all know that that came up because of a Google search, and we also know that the state had no clue how to respond to that. And them taking the stand and saying it was a Google search was their quick fix. And they were allowed to do that quick fix because this wasn't a fair trial. He has no idea necessarily if the logs would or wouldn't say if there was water damage or dirt in the phone during the time of this whole headphone jack incident. But the fact that it came up and they weren't prepared is a poor excuse. That headphone jack part of this story completely destroys the state's timeline. In fact, it's also my understanding that there's no time of passing to begin with, so nobody really knows the timeline at all. It's honestly exculpatory for Richard Allen, because the state said Richard Allen committed this crime, left the crime scene, and never returned. But this proves somebody else was there. Maybe a couple of people were there, possibly 3 for example. Which leads us to this motion to preserve evidence and what Mr. Davis told the defense, and apparently told Nick Mcleland. Listen to this.
The latest in the ongoing legal saga of the Delphi double attorneys for convicted Delphi murderer Richard Allen are asking the judge to force the prosecutor to turn over interviews and documents that they say point to alternate suspects.
They should have already turned all this over.
Abby Williams and Libby German. Now they're asking for that evidence to be preserved for now and then eventually turned over as they attempt to overturn Allen's guilty verdict. Those records specifically are letters written by inmate Ricky Davis to prosecutor Nicholas Mcleland.
Multiple letters.
In those letters, Davis told prosecutor Mcleland about conversations he had in prison with Ron Logan. Now, Logan was the owner of the property where Abby and Libby's bodies were found and was once a suspect in their murders. Davis alleged that Logan confessed to being involved in the murder alongside 2 other people. Davis also claimed that Kagan Klein, another inmate, had told him information that, quote, could only be known by someone involved in the case. Klein also allegedly told Davis that Richard Allen was not involved in the murder. Neither Logan nor Klein identified that 3rd supposed suspect.
And let's stop talking about this whole no nexus nonsense. There is more of a connection between these individuals and those 2 victims than Richard Allen and those 2 victims. I mean, this blanket response, there is no nexus, just isn't going to cut it. We understand that that's what the judge said. But when there is obvious bias, are we really believing what the judge said? There's multiple connections here. There's multiple confessions. And there's multiple problems. And this is what happens when you don't let the jury be the finder of fact.
Now, the new filing requests that any letters, recordings, records, or anything related to Ricky Davis from law enforcement agencies be preserved and handed over to the defense. Fox 59 tonight. We do have an exclusive development in this story just coming into our newsroom a couple of hours ago. Today, we did receive a letter mailed to us by Ricky Davis, the inmate at the center of all of this. We had originally requested to go and interview Davis, but the Department of Corrections turned us down for, quote, security reasons. Now, in this letter, Davis told us that he sent multiple letters about the supposed confessions to prosecutor Nicholas Mcleland, said they were all ignored. He told us he believes Richard Allen is an innocent man and he wants to get justice for the girls. You can read his full letter right now on fox59.com.
Well, technically you can't read the full letter because nobody can decipher what this guy says specifically, at least not all parts of it. But let's talk about this motion to preserve evidence. Now the nexus, so to speak, since everybody loves talking about a nexus, is Newcastle facility, where Davis, Logan, and at one point in time Klein were all there. They weren't there at the same time, but Mr. Davis is the common thread between all this stuff. As it says in the motion, Klein found out that Davis and Logan had been talking about the Delphi passings, and he became insanely interested in knowing what Mr. Davis heard from Logan. Davis goes on to say that Klein and Logan know each other because they're both chomos, and Logan had a very difficult time using his burner phones and would have to call Klein to help him since Klein was more tech savvy than Logan. But here's the problem, and here's the potential reason this whole case needs to be dismissed. At their February 12, 2025 meeting, Davis further admitted that when attorney Baldwin met with Davis on March 27, 2024, he did not provide all the details that he knew at that time to attorney Baldwin for two reasons. He had not yet heard of many of the details that Klein ultimately provided him, and at the time he met with attorney Baldwin in 2024, he could not be sure whether Richard Allen was one of the other two people that Logan described and also being involved in the passing. Davis stated that he was guarded during their March 27, 2024 meeting because he did not necessarily want to assist Richard Allen's defense if Richard Allen was one of the three men Ron Logan had talked about. And I do have to say, in terms of credibility, because we try to be fair, if you legitimately cared about those two individuals and you knew that there was more than one suspect, you should have said something sooner. I get that. I'm not saying his entire statement needs to be thrown out and completely disregarded. I'm just saying this needs to come in and let the jury hear this, let the jury be the finder of fact. But there's more, listen to this. Again, in his March 27, 2024 meeting with Baldwin, Davis told Baldwin that he could learn the details of what Richie told law enforcement by watching his videotape interview that law enforcement should have in their possession from when they interviewed him some years before. At their February 12, 2025 meeting, Davis was shocked to learn that Baldwin had never received this videotape interview before. And here's the problem, and one of the reasons this could very well lead to a full-on dismissal. Everybody needs to keep in mind the state doesn't get to dictate what the defense is going to use in terms of potential exculpatory evidence. Any and all exculpatory evidence needs to be turned over to the defense per state and federal law. That is how we ensure there is a fair trial. But if what I'm about to read holds true, it signals a very large problem within this whole Delphi situation. On February 13, 2025 at 3:54 p.m., attorney Baldwin sent another email to Mcleland asking straightforward questions. Did you receive multiple letters from Davis in the months leading up to Richard Allen's trial in October of 2024? And if so, did you turn those letters over to the defense? These should be questions easily answered and quickly answered. If Mcleland never received such letters, he should know that answer immediately since Davis claims that he sent letters directly to Mcleland. If Mcleland did receive such letters, he should know that answer immediately. Furthermore, if he did receive such letters, he should very quickly be able to identify the dates that he sent those letters to the defense and how he sent them to the defense. Now this is a problem. What the defense is saying is they've reached out to Mcleland multiple times about this, and any potential exculpatory evidence should have been sent to them. If they can prove that these letters were sent to Mcleland, and if they can prove that they've requested all this stuff in the past and it was never sent to the defense, and they can prove that they've reached out to the state multiple times, this should 100% be a dismissal for Richard Allen. Albeit a dismissal on a technicality, but once again, it's not our fault. It's the state's job to do this right. And don't say if this was a problem, they should have brought it up at trial. The motion in limine was filed. A lot of this couldn't even be brought up at court. Because once again, there's apparently no nexus when it seems like there's a nexus everywhere you turn. But this is all brand new information within 24 to 48 hours, and nobody's heard anything from the state in terms of a response to all this. We'll see how this plays out, but it does reiterate what a lot of us are saying. This trial wasn't fair. This trial was biased and evidence was withheld. If you're a fan of justice, you should absolutely be up in arms. If you don't believe Richard Allen deserved a new trial after hearing this, I don't know what to tell you. You can believe he's guilty all you want, but let's pull the bias out of it. If it's not done fairly, it's not done right. And if it's not done right, we don't have justice. But if you enjoyed this and a more fair, open conversation, maybe check one of these videos out. Y'all be safe now.